Hello, my name is Scott Eichelberger, and I'm the president of the Breathe Easier Alliance of Alabama, also known as the BEAA. The BEAA is a trade association formed in March of 2015, comprised of retailers, manufacturers, consumers, and affiliates associated with the vapor industry to lobby for honest and fair regulation, with key word there being honest and fair. In May of 2016, the Food and Drug Administration released its deeming regulations, containing hundreds of pages aimed directly at the personal vaporizer and e-cigarette industry. If enacted as written, these regulations would impose unfair, costly, and burdensome rules directly affecting vapor retailers, vapor manufacturers, and affiliates that will force the overwhelming majority of these businesses to close their doors. In Alabama alone, this will affect over 200 businesses, thousands of employees, and cost the state and local governments millions of dollars in sales tax and income tax revenues. Each of the three plaintiffs here are members in good standing with the BEAA, and we're proud to support their effort to fight these regulations, because they're fighting not only for themselves, but for all businesses, employees, consumers, and affiliates of this industry. Not only am I the president of the BEAA, but also am owner of Bama Vapor in Birmingham, Alabama, and these regulations are going to affect 8 of my employees and 7 families associated with our business. We believe the FDA's process is broken. These regulations are unconstitutional, and if enacted, our industry will suffer, and both our constitutional process will suffer. Thank you for your time.
Hi, my name is Zach Carpenter, co-owner of Cyclops Vapor 2. We sell and distribute e-liquids for use by adult consumers all over the world, right here from our beautiful state of Alabama. We take great pride in our work, and we are proud to be a tax-paying business right here in the river region. However, if the FDA gets its wish and the deeming regulations are enacted how they are written, more than just my business will be destroyed. Thousands of businesses across the country, with hundreds in our own state, will close and leave little to no access to these life-changing products. Thousands of jobs will be lost, and our rights, along with the rights of millions of Americans, will be trampled. Vaping products do not contain tobacco. They do not produce smoke. There is no flame. These liquids, many of which contain no nicotine at all, are consumed using battery-operated electronic devices. These can be described as technology. These can be described as a lot of things, but the FDA's attempt to define these products as tobacco when they contain no tobacco is malicious, fraudulent, and wrong. An internationally recognized body did an extensive study on electronic cigarettes and e-liquid. The study found these products to be at a minimum 95% safer than combustible tobacco. But the FDA has refused to accept this research and continues to treat these products the same as a product that kills upwards of 480,000 people a year. We are all for reasonable regulations to protect the consumers that use our products and to keep them out of the hands of our youth. But this rule is far from reasonable. It is disastrous. If the federal government can redefine words like tobacco in order to punish legitimate, law-abiding companies, where will it stop? What word will it redefine next? What industry will it target? There will be no reasonable boundary to the power we will allow the federal government to have if we allow it to rewrite our lexicon and to violate its own Administrative Procedures Act, exercising its powers outside the bounds of the law, and to target any industry and any company that it wish without facts or cause. The FDA has exceeded its statutory jurisdiction with these regulations, and in doing so, these regulations should be barred from taking effect. We are asking the court system for such just relief. We ask our judicial system to protect every American business owner, employee, and consumer from the illegal and obtrusive interference of the federal government. Thank you.
Hello, my name is Robert Ware, and my wife and I quit smoking February of 2013 with an electronic cigarette. I had smoked for 34 years and she had smoked for 20 or so. And it was awesome. I mean, I quit that day. I haven't had another cigarette since. And about 6 months after that, we decided to open up a small business called Tiger Vapor. And since then, we've opened up a store here in Montgomery and also one in Dothan. The FDA has come out with the deeming regulations that are going to shut my doors. And 95% of vaping stores just like mine across the country, and all the businesses that support those stores. So with these regulations, I feel like they violate my constitutional rights. I cannot tell a customer that comes in my store my story, that vaping helped me stop smoking. And that's just wrong. So what they're telling me is that if you work hard and you're smart and you play by the rules, that they can shut you down at any given moment. So even if you are smart and you play by the rules, it doesn't work sometimes. And that's why we're suing the FDA. Thank you.
My name is Karen Anderson. My husband Jamie and I are the proud owners of Operation Vapor in Daleville, Alabama. We're honored to serve our customers, especially our military men and women and their families who come up to our store that is just about half a mile outside of the Fort Rucker gate. Every day, I have the opportunity to wait on people in my store who have volunteered to put their lives on the line for our freedom. They are willing to make the ultimate sacrifice for the rest of us, to protect and to defend the Constitution, and to ensure that our freedoms are protected. I'm honored to serve these men and women, and I'm proud to be a business owner in Daleville. I operate a clean store that meets all laws, local, state, and federal. I sell a variety of products that the FDA wants to tell me are tobacco products. The irony is that nothing in my store contains any tobacco. Nothing in my store produces any flame, and nothing in my store produces any smoke. I do not sell tobacco or any tobacco product, and I don't want to. I do not sell any product that could even be used with tobacco. I'm not a part of the tobacco business in any way. Anyone that comes in our store, they're looking for tobacco, is going to be disappointed because we don't have any. I sell e-juices. I sell devices that customers use with their e-juice. These are made of plastic, glass, and metal. There's no tobacco here, but the FDA says the product is made from tobacco. I sell batteries and coils. Clearly, this is not made of a tobacco leaf and is not a plant-based product, but the FDA says that it is. These regulations rely on each of us accepting that these pieces of metal and plastic and these liquids are in fact cigarettes. That defies common sense, that defies logic, and that defies the law. After redefining the word tobacco to include liquids and metals and plastics and glass, the FDA then picked a date in 2007 as a predicate date because they knew that these products were not on the market at that time. This date was chosen specifically to target this industry. That is punitive regulation, and besides being illegal, it's counter to everything this nation was founded on. This process stifles technological innovation and crushes the entrepreneurial spirit. This FDA process is everything that is wrong with government, and through this lawsuit, we hope to be a part of correcting that. Please understand that we're not opposed to regulations and oversight. We're not opposed to things that make sense. But we are opposed to hundreds of pages of baseless, illegal, contradictory, unconstitutional, punitive regulations set forth by the FDA with the sole purpose of crushing an entire industry. Thank you.
Any questions? Kelsey?
Yeah, so is this the first suit to challenge this regulation?
No.
Or do other suits have-
No, there are 4 other suits pending right now, not in Alabama. This is the first suit in Alabama. The 4 other suits pending, there is one in the Los Angeles District Court. There are 3 others in the DC District Court. the District Court for the District of Columbia. The DC District Court is a court that is focused primarily on administrative regulation. We chose to file this here in Alabama because we understand and have faith in the people of Alabama that they know what obtrusive government looks like. They know what federal overreach looks like, and they will be the ones to hear this case and to decide the extent to which the FDA is overreaching its statutory and constitutional bounds. Anything else? Yeah? Thank y'all so much for being here. Stay tuned. It'll be an interesting ride.